Hi, I'm Andrew Meinzer of Meinzer Law Firm. This is the sixth and final video in a series regarding estate planning. We've discussed that there are two primary goals for estate planning. The first goal is to distribute your assets at your death the way you want and efficiently meaning with a minimum amount of effort, delay, taxes, fees, and other expenses. And the second goal of estate planning is to make sure that someone that you know and trust will have the legal authority to take care of you if you cannot take care of yourself anymore in the future for some reason. We've also discussed how documents such as wills, trusts, powers of attorney for financial management, powers of attorney for healthcare, and disclosure authorizations carry out these two goals. And we looked at your options for language that provides for distribution of your assets at your death. So after all of that, the question is, who should have an estate plan? And most likely the answer is you. Every adult 18 years old or older really should have some type of estate plan documents in place. We naturally think of estate planning for senior citizens. Death or lack of capacity due to heart attack, stroke, dementia seem more relevant for senior citizens. Further, senior citizens have had more time to amass assets for distribution after their death. And if you are a senior citizen, then you ought to have estate plan documents in place to handle these issues. Often, though, estate plan documents are more critical for the next generation in their 40s or 50s. By that age, many people have already amassed substantial assets. Further, someone in their 40s or 50s may still have minor children. Without estate plan documents containing proper language regarding distribution at death, a court guardianship proceeding may be required for each minor child. That would result in a great amount of effort, delay, fees, and other expenses that could be avoided with the trust. And although heart attack, stroke, and dementia are less likely for somebody in their 40s or 50s, they're still possible. Plus, it's possible to die or become incapacitated in an accident while, say, driving, cycling, skiing, swimming with sharks, jumping the Grand Canyon in a motorcycle, whatever. But accidents can happen, and it's important to be prepared. So we've talked in prior videos that if you don't have a trust, then whether or not you're going to have the time, delay, and expense of a probate decedent's estate court proceeding, it depends on the value of your assets. Most people in California have enough assets where they're going to be in a situation where they're going to have a probate decedent's estate court proceeding. If you have real estate in California, that probably puts you in that category. Another reason to have estate planning is you perhaps want to leave your assets to somebody when you pass away, and that person receives government benefits that are based on financial need. In that case, leaving assets to him could terminate his government benefits. Instead, you can leave those assets to him to improve the quality of his life while still allowing government benefits that pay for his necessities by leaving the assets to him in what's called a special needs trust. And even a young adult college student with no substantial assets should have some kind of estate plan in place. A college student could die or become incapacitated in a sports accident, car accident, etc. In that case, it would be critical for someone such as a parent to be able to make her decisions for her through a power of attorney for financial management, power of attorney for healthcare, or disclosure authorization. So you can see that it's worthwhile for every adult to have some type of estate planning documents in place. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning, or even if you just have a question, please contact us and let us take care of you.